We'll go over it a bit to begin, but anything on your minds in general? All right, let's start off with this question. It's in your book on page 390, or I have it up here, either one works. And this will help bring us back into the topic we began last class. The question is on page 390, question number 3. It says, A and B are planning to be married. 2 weeks before the ceremony, they buy a house and take title in A and B as tenants by the entirety. The question is, what interests does A and B have? Oh, I can't. My grammar's not good. What interest does? Sorry. A, tenancy in common. B, a joint tenancy. C, tenancy by the entirety. Okay, 30 seconds or so. We'll stop it there. Who's next? Edwin, thank you. Did you enjoy that talk over lunch?
Yeah.
Okay, very good. Yeah, there was a good event today. A friend of mine, Ed Whalen, who wrote a new book on Justice Scalia. So, you have time for some questions also at the end?
No, I came back here.
Yeah, I know the timing's not good, but I'm glad you're here on time. Made the right choice. Edwin, what's your thinking here? What do A and B have?
Okay. I believe they have joint tenancy.
Okay, why do you say that?
Because both A and B own it in the entirety, so there's no division of interest.
Well, what does that mean by the entirety? What does that mean?
Because they both together own 100% of it.
What does tenancy by the entirety mean? Do you remember? Are you guessing?
Oh. They own it together because they're married.
Aha. So Evan, remind us, what's tenancy by the entirety? Give me the full definition, my friend.
It's the 4 units: time, title, interest, possession, and then marriage.
Okay. So we have 3 kinds of co-ownerships we discussed last class. We have the tenancy in common. We have the joint tenancy. And we have the tenancy by the entirety. Okay? The tenancy in common is the most simple type of co-ownership because each party is a separate but undivided interest. What does that mean? They have access to the entire property, but they can sell their interest independently. They can also leave their interest upon their death to someone else. You can devise your interest. The joint tenancy is a little different. With the joint tenancy, at the death of one party, the other party now has to be simple. This is what's called the survivorship right. And it's the most important attribute of the joint tenancy. That when one person dies, the other one gets it now to be simple. There's no transfer. They all owned it all along. But to have the joint tenancy, you need to satisfy 4 criteria, 4 conditions. These are the 4 unities. They both take at the same time, on the same title, as the same with the same instrument. Number 3, they need to have the same interest, that is, they both have the same share in the land, 50-50. And they both have possession, access to the entire lot. If any of those unities are severed, you go back down to the tenancy in common. Then you have the special one, right? This is the last one, the tenancy by the entirety. The tenancy by the entirety is like a joint tenancy, but one big difference. You have a 5th unity. Marriage is required. You need to have marriage. The other big difference, though, is that both parties have to consent. With a joint tenancy, one of the tenants can sell it without telling the other one. That's what happened with the wife who was dying last week in class. But with the tenancy by the entirety, both husband and wife, or both spouses, as it were, have to turn the key. They both have to sell. So, Edwin, I'll go back to you, right? What interest does A and B have here?
Well, are are they married yet?
Read the question. I'm not telling you.
Okay.
What's the question say?
I think they join tenancy because they're still not married yet.
Ah,
They're married.
okay. So here's the trick of this question, right? It says they're planning to be married, and they take the title, but when they took the title, they're not yet married. Therefore, they're not tenants by the entirety. So the answer is not C. That much is clear. But then the harder question is, what do they have? Right? Do they have a tenancy in common or joint tenancy? And this creates a difficulty because the person who drafted this instrument made clear what they wanted. So how do we then figure out what their intent is? So Andres, let me ask you, between A and B, right, tenancy in common or joint tenancy, what's the right answer? What's the better answer? Sorry?
Joint tenancy.
Why do you say that?
Well, if you look at the 4 unities, it looks like they passed all 4 of them, so you could upgrade it to joint tenancy.
But is that what the parties intended?
Perhaps not, but I guess that's what they get.
Demetrius, what do you think? But we don't know if they wanted a joint tenancy. Perhaps they only wanted a tenancy by the entirety to protect their marriage, but let's say they never got married, right? Let's say they called the wedding off. What are we stuck with?
I mean, I think with tenancy in common, like they would have like a separate unified interest. I don't know. It's kind of hard to think.
Which is the
I
better?
would still think it's joint tenancy just because they both have like they meet the requirements for the 4 unities.
Okay. I think that's right. Oh, people are changing their answers. I hate when you do this. There we go. I think B is the better answer here. This often happens, right, where a party drafts an instrument and it doesn't work out as drafted. And then courts try to determine the intent of the parties. This is probably closer to a joint tenancy than tenancy in common. And I think that's even true because in the modern era today, we presume tenancy in common. At common law, you would presume the opposite. The presumption was of a joint tenancy. But I think even today, the nature of this problem, the way it's given here, I think it's better viewed as a joint tenancy. So what the courts will have to effectively have to do is rewrite it. And so where it says tenancy by the entirety, they'll just basically cross out the red pen and put in joint tenants. This one, those 5, you read the question carefully enough. They hadn't gotten married yet. So the 50 unity was not yet satisfied. I think A is plausible. I think B is a much better answer. Yes, sir, Rob?
Oh, if they actually get married, does it change until the next week?
I'm sorry?
If they actually get married in 2 weeks, does it change? Or does it
So here's the good point, right? When must the 5 unities be present? Say it louder, you said it.
at the same time?
At the same time. So the unities must all be present. That is, when they sign the document, they must be married at that time. If they get married subsequently, you don't have it at the same time, and that's an important unity. So you really need all of them at the same time. Yes, sir.
Does throwing a situation in a common law state like Texas, where you can create a marriage by contract representation, create a situation where you can become married by that purchase?
Let me put it this way. Texas is something of a weird thing because it doesn't really have a tenancy by the entirety. But let's just say, when you have a common law marriage, it gets weird. Some states have a requirement for common law marriage that you have to hold yourself as married for like X number of years. Texas does not have that. It's right away. So it does screw things up. Kind of can't. I mean, there's nothing wrong with common law marriage. It came from a day where people didn't have time to travel to the court to get documents. They just got married in the church, whatever. But there's nothing wrong with this create problems. Anyway, everyone see this problem? Why the answer is B here? Everyone understand that? I think B is the better answer here. A is not wrong, but I think B is better. Okay. All right. So today we'll continue our discussion of relationships among concurrent owners. Last class we described the 3 different types of these co-ownerships: tenancy in common, joint tenancy, and the tenancy by the entirety. Today we will discuss what happens when problems arise among tenants. And if any of you had any roommates in college or otherwise, you know that invariably two people just won't get along at some point. It happens. Now, with a college roommate, you're stuck with them for a semester or maybe a year, then you move on with your lives. But with co-ownership, it's not a temporary matter. You're in it for the long haul till one of you dies, or maybe one of you transfers it. And whoever transfers it first sometimes loses out on it. So there's always a risk of living with someone. And there's an old phrase that says, you should be able to use property so as not to bother anyone else, right? You can use property however you want so as not to bother someone else. But there's an easy response to this, right? Let's say you have one TV in your apartment, and you want to watch program A, and your roommate wants to watch program B. You can't both do the same thing, right? Someone has to get their way, or someone has to not get their way. You can't both do the same thing. So the law developed a couple different approaches to dealing with co-tenants who just don't get along. Okay? The first one is what's called a partition. Partition is exactly what it sounds like. Part, right? You chop it up. Right? If both of the tenants agree that things are just not working out well, they can together agree to divide it up. Now, if it's voluntary, there's no problem, right? If parties voluntarily agree, they can sever the tenancy however they want. The problem arises, however, when it's not voluntary, where you have two tenants, one of them wants a partition, and the other one does not want the partition. Okay, by the way, there's no partition with a tenancy by the entirety. It's another difference, right? You can have a partition for the joint tenancy or tenancy in common. You cannot have a partition with tenancy by the entirety. That's also protects spouses. So there are a number of protections for them. Okay. So there's the partition, but there's also something called the sale. Right? The partition is also something called a sale. A sale is something very different. With a sale, neither party wants to be there anymore. So rather than chopping it up, you put it up for sale, and then whatever proceeds are generated from the sale, you divide it according to the person's interest. This is actually Jolene's question from last class. This is where the percentages actually start to matter. Right? This is where it matters. So let's say both parties agree to a sale, and it brings in $100,000. If one person has a 75% interest, and the other has a 25% interest in the land, they chop it up, 75-25. The interest will matter when there's a sale. Now, what about when you're trying to do a partition in kind? Is it even feasible to chop it up 75% of the acres and 25% of the acres? Usually it's not. It doesn't work out that neatly. So the percentages help when you're doing dollars, but when you're doing a partition, percentages are really hard to divide up. You can get a general approximation, but often it's, like in the first case, it's going to be based on the specific factors of geography, where things are, who's using what. But there's a question, right? What happens if neither party agrees? One party wants partition, the other one wants a sale. Right? Courts then have to step in and resolve. And when you think about it, especially in the first case, the Vealencis case, when you sell the land, you're not just taking someone's property away, you're also taking away their livelihood. This is where they work. And how do you factor in that cost when you're making a decision of sale, partition, or none of the above? Right? That's always an option. It's like, you guys figure it out yourselves, not going to help you. So courts take different approaches, and a few of the cases, the little short cases, the squib cases, do allude to this. Okay. By the way, I did ask about that footnote about the marital property issue for the Sampson couples. I did not get a response yet. I did ask about that. Someone asked me last week who it was. Yeah, I did ask, but no response yet. Okay. So any questions on that so far? Yeah, Khadijah, you want to give the facts, please, in Delfino versus Vealencis?
Okay, so this case involves tenants in common.
Who's they? Okay, good.
And so the pay on the divided on the 44th entry for the property is 45 entries on the depending on like the garbage business on her side of the land and the plaintiff was a residential developer, and neither party had actual possession of the land.
Good.
So the plaintiff brought an actual two parties from the property out there that you wanted to do.
Okay, very good, very good. Thank you. All right. So we have a situation, right? We have a single plot of land, and we have several parties who are on the land. The plaintiffs are Angelo and William Delfino, right? Even I think they're husband and wife. I'm pretty sure that's right. They are the owners of an interest in this land. They have a tenancy in common. The other tenant is Helen Vealencis. I think there's a picture of her somewhere in your book. This is Helen on the right. Okay. I don't know how they came up with these numbers, but these are the numbers. That the plaintiffs have a 99 of 144th interest. I don't know how that number came up with, but that's the number they have. The defendant, Helen Vealencis, has a 45 over 144 interest. Right? Those are the numbers, okay. And by the way, it's in Bristol, Connecticut, which today is most famous home of ESPN. The property is used primarily by Vealencis, and she runs a garbage hauling business. Now, just to be clear, she's not putting garbage on the lot. She's not putting garbage on the lot. This is used to store trucks and other containers, but this is not a garbage dump. As far as we can tell, the Delfinos don't do anything on the land. Okay. And I think I have a map here. This map's a little bit better. It's a satellite photo. You actually see where the garbage hauling lot was. So the plaintiffs probably said, screw this, we don't want to have this garbage business, we want to make some money off this land. They were developers. So they went to court, and they sought a partition of the property by sale. The terminology here is confusing, right? They call this a partition by sale. Why would they call it that, right? Why would they use the word partition and sale in the same sentence? I don't know, but you'll see this sometimes. So it's called a partition by sale, but they're actually talking about a sale. So don't get mixed up with the terminology. Partition by sale means a sale. Then you have what's called an in-kind partition, or also you'll see sometimes a partition inclined. You see it both ways. I'll accept either one, right? The plaintiffs wanted a partition by sale. That is, they want to sell the lot, and they would get 99 of 144th, whatever that is. Just call it 2/3. Is that my math about right? We'll just call it 2/3 and 1/3. Make my math easier, right? Okay? Make my life easier, right? So the plaintiffs will roughly get a 2/3, and the defendant will get roughly 1/3. So if it brought in $100,000, they will get 66 grand, whatever it happens to be. The defendant, though, wanted a partition in kind. She wanted to actually chop up the land and give her a certain portion of it for her garbage business, and the rest of it could be used for the residential community. Right now, Kendall, what do you think the trial court thought of doing a partition in kind here, or an in-kind partition? What do you think the trial court thought about that idea? Good. Why? A little bit louder, please. Did the trial court think a partition in kind would work? No, why not? Just in simple words. Why was it impracticable? Well, no, they could have, but as a practical matter, what did the plaintiffs want to do with the property? Very good. So the issue is this. The plaintiffs want to turn this into residential houses. And they said, look, we can't have residential houses with a garbage lot next door. I think you did in towards the Del Webb case. You see that one yet? Coming to the nuisance? Sound familiar? It reminds you of this case a little bit, right? That you're going to build a bunch of residential homes right near a garbage hauling business might create problems. They also raise other issues which you haven't studied yet, so I want to ask you about. But it's one of zoning, right? Generally, a garbage business inside city limits would not be allowed. But if the business had been there for a long time, it was grandfathered in. And there was a debate about whether the grandfathering would continue if there was a partition in kind, that you'd have to move your stuff around. So anyway, the trial court was not interested in giving the partition in kind. They said we have to consider the best interest of both parties, not just one side. And we don't want to have a garbage lot near residential communities, so we will simply put a sale for the entire auction. By the way, who's going to buy it? I have to guess, the plaintiffs. So there will just be an auction, the plaintiffs end up buying it, and they get the entire interest against Ms. Vealencis' will. You're with me, right? All right, Zach, what did the court do on appeal?
On appeal, they disagreed.
They did, why?
Well, they said that they were considering the wrong factors.
Good.
So, because Ms. Valencia had been like legally practicing with the garbage home before the zoning laws came in, that she could probably continue practicing even if they had done a partition income instead of by sale, and so that it wasn't right to rely on her not being able to, or assuming that she wouldn't be able to continue her business.
Okay, very good. So the Court of Appeals, or the Supreme Court, whatever one, the higher court in Connecticut, explains that the lower court didn't consider the balance correctly. The state had a long-standing tradition, going back to the 1700s, of not ordering sales. That the strong preference is, where it's practicable, to do a partition in kind. And that to overcome that long-standing presumption, the court must provide very specific evidence. Why? Ms. Vealencis would lose her livelihood. Right? It wasn't just her home, it was her place of business. And so long as it's possible that the burden should be on the party promoting the sale. Right? If you want to promote the sale, you have to show why. It should not be on Mrs. Vealencis' responsibility to show why a sale it should not be had. Right? Do you know this concept of burdens in law? It's a very important concept, right? Think of it this way. The trial court put the burden on Ms. Valencia to show that you should not have a sale. The Court of Appeals put the burden on the plaintiff showing why you should have a sale. Generally in law, if you have the burden, you're going to lose, right? Because you have the responsibility of proving all these various points. What the Court of Appeals says is it should be on the party seeking the sale. They have the burden of proof. Whereas the trial court put the burden of proof on the person fighting the sale, and it reverses it. You'll see this a lot in constitutional law. Whoever has the burden of persuasion almost always loses. Not always, but almost always. If you want to tell me how a case comes out, tell me what's the burden, I'll give you the answer. It's almost always the case. So here they said it's possible to subdivide the property. You can put Ms. Valencia's little green pentagon. Put Ms. Valencia's business closer to the main road, and that way it won't bother the other businesses, the other homes. Even if it's a case that you can build fewer homes this way, so be it. It lets her livelihood continue. So the court ordered an in-kind partition rather than a sale. All right, so we'll get the holding of the case. If we get the case, not that hard. Now, Samantha, did this work out for Ms. Vealencis in the end? Was this like a good deal for her? No. Why did you have to pay a lot of money?
Because of the burden of what they consider the burden of the business was, and the state of the development and what the clinic was trying to do with the land, and just the land in general, so it didn't end up very well.
Yeah, so the way this works is the plaintiff had to make a one-time payment of, was it $26,000 to the defendants. I'm sorry, the defendant has paid 26 grand to the plaintiffs to compensate them for running the garbage business. This was an amount saying, we are depriving of your property value, we're going to pay you once. So Ms. Vealencis didn't make much money off this at all. And in fact, she had a pretty rough go. She probably should have just sold it, but that would not have worked out well. Okay. Any questions on the Vealencis case? So despite the Vealencis case citing 300 years of precedent, the modern trend, you was asking about modern, right? The modern trend is towards preferring a sale. Delfino is probably an outlier, more of a common law case. But the modern approach is a sale because generally people living together is not a very happy thing. They don't want to be there. And a sale at least gives you something. There are two little cases mentioned in the notes. One is this Ark Land versus Harper in West Virginia. And there was these 75 acres owned by a family. And the land had been in their family for 100 years. And then a coal company comes along and says, aha, we found coal. And they try to buy up a couple of the shares, basically buy up a few of the family members, and then say, we want to buy the rest, partition by sale. The court held that no, you can't force the sale. You can't compensate for sentimental value. That really matters with coal because if you don't own all the land, you can't drill everywhere or dig everywhere. That makes a huge difference. But then the other case, this Johnson versus Hendrickson case, goes the exact opposite way. The court looks at what's the total value and which sort of sale can yield the most social benefit. And this is probably more in line with the modern trend. Any questions on that? Marcella, on page 614, there's a little note, question number 6. Oh, not 6, I'm sorry, 414. Sorry. There's question. That scared you a second, right? Question 6 on 414. I interpose the numbers. So it says this, Marcella, right? A and B are heirs of their father, who own one item both A and B very much want, an old rocking chair. They can't agree. A brings a partition action. What happens here, Marcella?
What relief? You're asking me like.
Yep. You're the judge. What do you do here?
Sell the chair and give them the.
How much is a chair going to sell for? Not much. It's an old beat up rocking chair. Will that make either of them happy?
No.
No. So what do you do?
This is why the court is not gonna.
I'm asking you. You're judge. You're the judge. What do you do? Thank you.
I would tell them to figure it out.
They can't. That's why they came to you. And they ordered a partition. What are you going to do?
You can't like cut the chair.
Ah, so Solomon, right? You have the two women who come to King Solomon and say, the baby's mine. No, the baby's mine. What does King Solomon say? I will cut the baby in half. And the mother says, okay, go for it. That's not the real mom. And the mother says, don't do it. That's the real mom. Now, Solomon doesn't actually cut the baby in half. But here, do you cut the chair in half? You can't like rock half. Oh, that wouldn't work. Lucas, what do you do here?
I would basically look at A and B's interest and weigh it to see if
They're identical twins.
I'm saying,
They're identical twins. Equal attachment to the chair. Both have a good claim.
Just sell it and then divide the proceeds.
Yeah, but that's what Marcella said. Will that make anyone happy? They don't care about the chair because of the money. Justin. It's fair. Okay, Justin, what do you think?
I think it's the only option.
Is the only option? Is there no other option?
Divide the time.
Custody. Yeah. I think that's the idea.
A gets it for 6 months of the year, B gets it for 6 months of the year. Marcella, you're shaking your head no. Why is it not a good idea?
Like now the court is going to get custody of a chair.
They move for partition. Why can't you partition it that way?
No way.
No way, no way. Brooke, what do you think? No? What?
No, I actually heard a case on taking Will's trust in states, and
Yeah.
these two sisters were arguing over their mom's son's ring. So every Christmas they have them
Switch it.
off, so they get it like every other year.
Yeah, custody of a ring, custody of a chair. Yeah, I think that's well, think about it this way, right? Cutting the chair in half, not going to get anyone happy. Selling it, it's not going to get much money because the sentimental value is probably worth more than the actual damn chair. At least with the partition in time, they'll be happy to the time. Now, Marcella raises a fair point. Is the court really going to make sure that every Christmas they hand off the chair? Probably not. Do you go to court for an emergency temporary restraining order because they didn't bring the chair over? Anyway, it's you can look up the case. The citation's there if you want to look up later, but I think that's probably the right answer.
Trial by combat?
Trial by combat, oy vey. You know what that is, everyone? We basically fight to the death. No. Maybe. Make law school a lot easier. We have the jousting class that have like future interests. All right, anything else in that one? All right, let's move on. The next case concerns the possession interest. This is Spiller versus Mackereth. And we discussed with the joint tenancy, you have to have these 4 unities, right? Time, title, interest, and possession. And I made this point throughout. With a joint tenancy, you have to have access to the entire property. You can't section part of it off. The same rule applies for a tenancy in common. One tenant can't block out the other tenant. So the Spiller case involves a word which you may have used, but perhaps never used it in the legal context, which is oust, or an ouster. And the court spends a lot of time trying to figure out the meaning of this word, and it's not particularly clear what the meaning is. But in property, this is a context of basically throwing someone out, taking some specific act to remove someone from the premise. Now, an easy act of ouster, if you literally pick them up and throw them, right? That's an easy ouster. What happens if you put up a gate? Well, can they open the gate? Do they have a key, right? What if you put up a lock on the door? What if you charge rent? What if you ask your tenant to do something? The hard cases is when the possession element's severed, when it's not something clear like putting up a locked door. And that's what Spiller versus Mackereth is testing on. Okay. I think, yeah, Dylan, you want to give me the facts, please, in Spiller and Mackereth?
Sure. So, Spiller and Mackereth own the building, and Tuscaloosa's tenants in common.
Roll Tide, right? Yeah.
Yes. And I guess they were leasing part of it out to Auto Right, and that company eventually left, and so Spiller started using that part to like store some items, I believe.
Uh-huh.
And then so Mackereth didn't like that, and he wrote a letter demanding that he either vacate or pay half of the rental value of the space. And Spiller didn't either, and so that's why they're in court now.
Yeah, yeah. Very good. Thank you, Dylan. So as a general matter, people in court are unhappy, right? If everything's cool, you don't need to go to court. You only go to court when there's a conflict. So here was the conflict. You had these two people, Spiller and Mackereth, and they owned a building. So long as a tenant was there, they were happy. Why? The tenant is paying rent. And when you have a tenancy in common and rent is coming in, rent is divided up based on the interest. So if they have a 50-50 share in the property, they get half the rent, everyone gets half the rent. If it's 75-25, they split the rent accordingly, right? So long as a tenant's in the building, everyone's fine. But after the tenant moves out, it's a problem. Because one of the parties was depending on the rent, and the other party starts putting his stuff in there. So the other party's like, well, wait a minute. I was getting rent before, and I wasn't using it. Now you're using it. I want rent from you. There's a general rule that one tenant can't demand rent from the other tenant, right? So as a legal matter, they can't force the payment of rent. the question for you to think about is the even request to pay rent an ouster, right? Does asking for the rent by itself sever the tenancy and constitute an ouster? So, Katie, what does the court do here?
Well, when Mackereth sent the letter to him and like asked him to either vacate or pay half of the rent, they said that that's what they provided for proof as an ouster, and they said that it wasn't because it didn't demand equal use and enjoyment, and it didn't necessarily prevent him from entering, and he didn't request to enter. So.
Very good. So, Kate, let me ask you a follow-up. Was there any legal effect of demanding rent? Is there any actual legal effect of making that request? Yeah. It's as if it never happened, right? So the demand for rent was basically meaningless. Because it couldn't be enforced, there was no actual demand, and that was not enough to constitute an ouster. But that doesn't end the inquiry, right, Alec? What other? Oh, they were on that. Sorry. Name tag was right in the middle. It's borderline. So, Lance, the mere fact that the request for rent was enough, that doesn't end the issue. What else does the court consider here? What's the important fact? Not the rent, but what actually matters here?
Like whether he denying them from like entering.
Yes. Okay. And this is the important point, right? With possession, this is the P element, right? You can't deny entry. So now, Alec, is there any evidence that there was any sort of effort to deny entry to the? Okay. Now this is important. There were locks on the door. Is that definitive proof that there's denial of entry?
They said no because their shadows that he was protecting the previous tenant had taken the locks, so he was trying to protect his property.
Right. So what fact here is important? What did the locked out tenant never do that would have actually mattered? No. One guy puts up a lock. The other guy says, "Aha, I'm locked out." What didn't happen? Asking for a key. This is an important point. He never asked for a key, right? Stephanie, if he had asked for a key and he was told, no, you can't have one, then what would happen? Yes, ma'am. If there was a request for a key and the key was not provided, I think that would be enough for an ouster, because that's proving you're locking the person out. But here, there was never a request for a key. And I think the court's right here. This is pretty obvious. The mere fact that you put a lock on a building cannot be an ouster, because you have to secure it, right? You're putting merchandise in there. You're in downtown Tuscaloosa, and if the Tide, if they lose a game, it's gonna be a riot. You have people robbing your stuff. So you need to have a lock. Okay? So that much I think is straightforward. He never asked for it. Now, Harrison, let me ask you a question. This will be a little bit bizarre. We say that with a tenancy in common, right? You have to have access to the entire property, right? So, Harrison, what happens if it's a warehouse, right? And he fills up every single inch of the warehouse with merchandise. And the other guy can't even walk around, right? There's just no space to walk around. He can't use it for his own purpose. Is that an ouster? Why not? The door is like, he opens the door and like all this crap's just falling off on him, right? He can't even walk in the building. It's so full. Is that an ouster?
I don't believe so.
How come?
It wasn't an active purpose to keep him out, I believe.
Oh, so it's intent, you think, that makes a difference?
I think that has a big part in it.
Julian, what do you think? Is that an ouster? If this warehouse is filled to the brim, hoarder style, right? You see that show Hoarders? Hoarders, right? Every inch is covered with stuff, and you can't even open the door. That can be an ouster. Here's a key. You can't go inside.
So, definition of an ouster is basically throwing someone out.
Is it that? Is that the only definition?
That's kind of my question. What is
Yeah.
the actual definition of ouster without that explanation?
Yeah.
An ouster is a conclusory word which is used loosely in co-tenancy cases to describe two distinct fact situations. One is the beginning of the running of the statute of limitations for adverse possession.
Okay.
And two, the liability of an occupying co-tenant for rent to other co-tenants.
Yep. Does that help you at all?
Absolutely not.
No, ma'am. Yeah, okay, so Jolene is struggling with good reason, right? And she's not alone. This definition of what's an ouster is very tough. And the example I gave Harrison a minute ago, like, the warehouse is so full with stuff, you open the door and, like, it comes flying at you. Are you able to use the property? Do you have any access to it?
You could remove the stuff.
But could your roommates or your tenants sue you for some sort of a trespass to the chattels, right? That the stuff's not yours. The building is yours. Could you remove it? Ooh, Kendra.
Could you ask them to remove it, and then if they don't, could that be an ouster?
Could you sue them for failing to remove it?
Yeah, I guess if you ask them first, and they didn't do it.
Maybe. I saw another hand somewhere here. Yeah, Julian?
But they have possession of the entire property just as you do.
Yeah. But you can't walk around because there's so much garbage there. I don't have an answer for you. I asked this question for you. I don't have an answer. I think Kendra's probably on the right track. The best thing that I would do is go to court and ask for an injunction to not having the entire thing occupied. Al?
I was just going to say, like, wouldn't qualify as an ouster. Like, he hindered him from enjoying the company.
I think that might get close to it, yeah.
Even though, because he's a co-tenant, he knows that there's not a co-tenant too.
So what if instead of putting crap in 100% of the property, he put a crap in 75% of the property? Like you can walk in and you can't get past the front entrance. Can you still enjoy it? Where's the line?
100% if you can't walk into your property.
No, I'm saying you can. I changed it. 75%. You can walk in, but you can't walk around the warehouse. So you think anything less than 100% is okay?
Well, I'm just saying that is the line for sure.
That's the line.
For sure. You can't walk into your property nor you can't enjoy it.
Harrison and Julian. Okay, Julian.
The problem with that is if you even reduce it to 50%, even 10%, then you can't enjoy the entire property.
You can never. Can you ever enjoy 100% of your property? If your roommate wants to watch TV, you can't watch that TV. It's an example for it, right? So it's a really hard question because no matter what your roommate or your tenant's doing, that means you can't do that. Whatever he's doing, you can't do that thing. If he's using this space, you can't use it. Or to use the facts of the next case, if a boxing ring is purchased on some part of your land, you can't go there to plant almond trees or walnut trees, whatever they were, right? You can't plant trees there because there's a boxing ring there. So this case, I think, was correct, right? There was no ouster. But you can imagine a situation where he says, look, the warehouse is filled with so much garbage, I can't even walk around. How am I enjoying this property? And I don't know if it's clear that would be an ouster under this definition, which he gave a definition, Julian. It's not a very good definition at all. Okay. Yes, Anne?
If he had all this stuff, though, wouldn't it fall into the situation at the beginning of the running of the statute of limitations for adverse possession? Because isn't he adversely possessing it if you can't have use of it?
Yeah, you'll do adverse possession of property too. I deliberately don't want to cover it now. But the general rule is that when you are squatting on a piece of land for a certain number of years, you can actually gain ownership to it. But the reason why that won't work here is you can't squat on a co-tenant. It's not adverse, right? It's not hostile. When you're with your roommate or your co-tenant, there's no adversity, so there's no adverse possession.
Even if you're denying them complete access to that portion of the property?
Well, if it rises to the level of hostility, I think you have an ouster. And if you have an ouster, then the tenancy is severed. Yeah. So this case is correct. I think the bottom line, it reaches the right result. If he had actually put a lock on and not give him a key, I think it's a different story. But I think this case turns out okay. But it doesn't answer what happens of how you're actually using the property. The next case gets a little bit closer. Any other questions on Spiller versus Mackereth? Anything on Spiller? No? Okay. All right, let's do the next case. I think Miranda, you're next. Want to give me the facts within Swartzbaugh versus Sampson, California Court of Appeals, 1936.
So it's interesting because it's a husband and wife.
Yep. Yeah, shocking, right? It's like all of our cases the same. Never happens. Husband and wife get angry at each other. No.
The wife seemed to have leases the husband made with the defendant canceled. They have a joint tenancy over 60 acres for bearing premium walnuts. And the defendant approached the couple to lease a part of the land. The wife said she didn't want any part of it and didn't want it, and the husband went behind her back and made 2 leases with him. And the defendant then came off the land and started cutting down trees and building lots into the land. And while she was, I think she was on her sick bed while he was doing all
Well, Miranda, did she know what was going on here?
Yeah.
But what was her like position on this?
She didn't want it.
She didn't want nothing to do with it. So she, you know, how this works. Like it's like, honey, come sign these papers. No, I'm gonna go walk away right now, right? So you can imagine that she wanted nothing to do with boxing, right? Why? Because with boxing comes gambling. She said it, not me. Right? Women and booze, right? And it brings all sinfulness on her beloved orchard, almond, walnut. What the hell's a walnut trees? I don't know what these look like. I don't know, but beautiful trees, right? Julian, yes, ma'am.
So they purchased the land after they were married. So
Yes.
why was joint, tenancy in its entirety or by the entirety not a thing?
So we're in California. California is a community property state. Tenancy by the entirety doesn't really make a difference in community property state.
Okay.
That's a simple reason. But even there, even if it was a tenancy by the entirety, unless it's deeded as so, right? Unless the instrument says tenancy by the entirety, you can have a joint tenancy. To make this clear, you can be married and buy property, and as long as you say we want as joint tenants, that's what it is. You don't presume a tenancy by the entirety unless it's here. That's the opposite of my question at the beginning, right? Where they said tenants by the entirety, but they weren't married yet, so it's got nullified out. Good question. Thank you for that. Right. So we have this. Oh, yes, Marcelo, go ahead.
So in this case, could she have done the same thing as
Yeah. So everyone understand Marcelo's question. Our case last week, right? Where on her deathbed, the wife sold her interest to herself to sever the joint tenancy. Ever remember that? Right? The woman was on her deathbed, and she created this instrument to sell her interest to herself, cut out her husband, and that way her son gets it as a tenancy common. She could have done that. She didn't. She did something else. I don't know. She probably should have done what Marcelo said. It would have made a little bit more sense, because that would have, I think, put the boxing match in a very tough spot. All right, whatever. Jordan, so the wife sues then to have the lease canceled. We know that the wife didn't sign the lease. She wanted nothing to do with it. Does the issuance of this lease by the husband sever the joint tenancy? No, it does not. Why not?
Because he has the right to do what he wants with his portion of the property or his share.
Okay, but Jordan, let me just ask this follow-up question. We said last week, or last class, that there are 4 elements of a joint tenancy, right? That the parties have to take the same title, at the same time, the same interest, and have full possession. How does giving a lease to the boxing match not sever at least one of those interests? Well, let me ask you with that negative. Doesn't doesn't leasing the land sever at least one of those interests?
I mean, she still has possession of it.
Does she? Does she? And I made this question before, right? If the boxing ring is on the corner of the property, can she grow almond trees there? Walnut trees?
No.
So does she have full possession? All right, that's the P.
Yeah. I guess no.
What if they charge admission to the boxing match and they charge her an admission ticket?
She wouldn't have possession.
Yeah.
He has it.
Yeah, Neiman, let me ask you another one, right? Time, title, interest, possession, right? We talked about possession. What about interest? Do the husband and wife still have the same interest now? Well, you say no, why not?
Well, going to your example of charging admission, she obviously wouldn't have the same interest as the person charging it who has the same interest as her husband. She couldn't.
Well, Neiman, let me ask you a question like this, right? Before this lease was executed, what were the interests the husband and wife had in the property? But again, it was a joint tenancy. How would you characterize their interest before this lease was executed? Yeah, basically 50-50, right? Now here comes the difficult part of this case. Kendra, after the lease, what is the husband and wife's interest? It was 50-50 before. What is it now? This is the trick of the entire case.
Well, so there's a third person. So would hers be 50 and his would be split?
Did he divide his interest up, though? That's the key part of this case. Before, Neiman's right, it was 50-50, right? After the lease was signed, did the interest change?
I have no idea. I'm guessing yes. No?
Well, what's the holding of the case, Kendra? You're almost close. What's the holding of the case? Did the lease sever the joint tenancy?
It did not.
So let me ask the question again. Did the interest change?
No.
No. This is the hardest part of this case, right? You want to say, of course, he leased has interest. Nothing changed. With a joint tenancy, it's presumed they have a unified whole, right? They both have the same interest in the land. What the court basically says is, when one gives a lease, it's as if both of them gave the lease, right? Because they both have control of the property. Even though the wife didn't sign it, they both had the same interest, and the interest did not change. So, I think the possession, when severed, the court doesn't really talk about that. But according to the court, the joint tenancy survives. One second. That they both took it at the same time, the instrument was the same, and the interest that was conveyed does not diminish their relative interests. They say the possession is not a problem. That the lease was valid, and the lease, the joint property, was not a nullity but a valid contract. They even say that the joint tenant could mortgage their interest in the land. What they can't do is block them out with any affirmative steps. And if any rent is being paid by the boxing match, the husband will be obligated to give the wife a cut of the rent. But they say the tenancy survives and the wife loses the case. It's a weird decision. I don't know if this is right. I don't like this one. The other one I think is probably right. This one I think is probably wrong. Neiman, patiently waiting, sir.
I was going to ask about the unities.
Yeah.
But I guess it doesn't matter because it's not entirety.
Well, I think the unities are severed, right? If you ask me, if I was writing a dissent here, I would say the possession unity is severed, and I think the interest unity is probably also severed.
But okay, if it's joint tenancy and the time and the interest, the co-tenant can sell his interest, right?
But by selling it, that would sever it, right?
Oh yeah.
So the important point here is this is not a sale; it's a lease, right? And by leasing it, the court says basically everything's the same. There's just this guy here temporarily, but there's no change in ownership. So because it's a lease and not a sale, the court's willing to entertain this. Again, I have difficulty with this holding. Every year I teach it, I think it's probably wrong, but it's in the book and it's there. But again, what I say about California, they're about to reverse the common law, right? When there's a decision from California, they're probably going to do something that Blackman doesn't like. I've come to live with this in this class. I'm used to it. Celeste, what's your hand up?
On 423, when they talk about she may not lose her interest, are they talking about squatting, where you can renew the lease? Is that kind of what they're doing?
I think they're talking more about a permanent displacement, but the lease is sort of like a temporary thing. But again, she can't go where the boxing rink is. I think that's a very different idea. Julian, your hand was up also?
Yes.
It's a weird case. I know. You look troubled by it.
The postscript has now gotten me even more confused because now he's talking about conveying his interest, which I thought you had survivorship in.
Well, no, but a joint tenant can't convey their interest without the other one's consent. That was the case we did last week. Right. With a tenancy by the entirety, the spouses can't convey.
Okay.
But this was a case last week where she conveyed the interest to herself. That was permissible. So again, I think Marcella raised her hand a few minutes ago, made this point very well. If the wife wanted to screw this up, all she would have to do was sell her interest or even give it to herself, right? And that would just disrupted the joint tenancy, and then she would be on the hook for any sort of rent. Yeah, Marcella should have been her lawyer, right? I don't know. Yeah, I guess.
But since like maybe the argument can be made that the wife can't use wherever the box ring is, like couldn't technically the husband not use it either because it's left being stabbed to someone else? Yeah, he could. So wouldn't possession like essentially stay the same?
Oh, saying neither of them could use it.
Yeah.
I suppose whoever goes to court first makes that argument. Because if you wanted, this was a lawsuit the wife brought against the boxing ring. She didn't sue her husband. I guess she could have sued her husband. That would have been a little bit awkward. Who are these people that sue? I don't understand this stuff. These cases, the facts are very bizarre. But what you have to understand here is the court holds that merely leasing it rather than selling it is not enough to sever the interest unity. Therefore, the joint tenancy remains. But the wife is eligible to collect rent if any is paid. Yes, Marcella? Yeah, one is I think this is probably wrong, but this is a rule you can follow. My own understanding is this sort of lease would, well, there are cases on mortgages. This is far more common, right? Where let's say you have a joint tenancy and you take out a mortgage, right? A bank can put a lien on just your interest in the property. That's fine. And if you default, they can come after your interest. So you can convey your interest with respect to a mortgage. I think a lease is a closer call because there is someone else in the property who could potentially oust, right? My problem with this case is I think there is effectively an ouster by putting a boxing ring there. I think that's why I think this case goes around. I can deal with the fact that you can issue a lease, but the way the lease actually happens here I think is problematic because the boxing pavilion that's being built. Julian,
This is 1936.
Old, yeah,
right?
old case.
So the wife may not have been seen by the court as having as much power as the husband, right? So today, you know, because she, in her opinion, she still owns title to the entire property. She could start planting trees in the middle of the boxing ring, right?
She could. She could. And I don't think a court would have stopped her.
Okay.
I don't think a court could have stopped her, which is why the possession element here, I think, makes a big difference. The court didn't really go into it.
Okay.
Yeah, Mike?
Along the same lines, she could also, because she had the same rights as the husband who made the lease, didn't she have the same right to terminate the lease? Or to
evict the boxing guy? Well, she wasn't party to the lease, so she couldn't evict him on the terms of the lease, but she could have called the cops for trespassing, I suppose. Yeah. If he left the boxing ring, you know, if he walked around the other side, called it for a trespass. Again, this is very messy, right? When you have joint tenants and one who signs the lease, it creates bizarre facts like this. Not a good idea. They perhaps should have had a partition on everything, you know, for their marriage as well. It's called divorce. All right. Other questions? All right. Let me summarize and let you go a little bit early today. What you have to keep in mind with these interests, these three kinds, tenancy in common, joint tenancy, and a tenancy by the entirety, is what interest a given party has. With a tenancy in common, the interests don't have to be equal. Both a joint tenancy, they do, which is why I think in this case, the fact that the husband was giving part of his lease to someone else means they don't have an equal interest. That's why I think this case is probably wrong, but whatever. You have to have equal interest, and same for the tenancy by the entirety. I think your Langdell was canceled for Friday. You guys know about this? Did they email this? Yeah. Okay, so you should email. Garrett will make it up. But I told Garrett during your next Langdell, whenever it is, to go over the joint tenancy questions, okay? Next week we'll be starting family law, which sounds easy, but it's actually very complicated. So make sure you pay very close attention to the readings from rental property. Anything else? All right, I'll see you on Tuesday. Thank you so much.